Hello and welcome to the seminar series, Transdisciplinarity in Education and Research. This seminar series is organised by the Council of Hub 1, Climate, Environment and Energy, for the CIVIS Alliance, European University Alliance. Today we have the great pleasure of welcoming Rosa, Fernández, Egea, and I've been practicing pronouncing Rosa's name and no doubt made a complete mess of it, from the University of Madrid. Rosa is going to talk with us about international climate litigation. Rosa, I'm going to now turn my own camera off and I'm in the background and I will appear immediately if something goes horribly wrong. But that's just going to so that we get a really nice recording. So welcome to our seminar series. Rosa, the floor is now yours.
Thank you very much, Alistair. Hello, hello everyone. I hope you can see my presentation.
We see it perfectly.
Yes, okay, thank you. So today my talk is going to be a short of a follow-up session of the one on international climate negotiations that Professor Gundrup Zagel gave at the very first session of this webinar series. As we all know, global warming is a fact, and it is a global problem also. Therefore, international action and cooperation are very important to address the climate crisis. However, as also Gundrum explained, global efforts to cooperate at the national pledges made under the international climate regime are generally not enough and far less ambitious than they should be in order to prevent a climate breakdown. Nevertheless, there are legal ways to tackle climate change, and most importantly, to make states comply with their international obligations. It is true that states are sovereign and have almost unlimited powers within their borders, but that doesn't mean that they can avoid the compliance of essential rules and obligations, such as, for example, the protection of human rights. Actions or inactions of governments and public authorities can be controlled by judges and tribunals. And these cases, and when these cases deal with climate, with denouncing the lack of compliance with climate change, that is what we call climate litigation. And that is what I'm going to talk about today. First, I will go through some climate litigation data that shows that the number of climate cases is quickly rising all over the world. But since I will be focusing on international litigation, I will go over the definition of what international climate litigation is, and then explore the different international tribunals with potential jurisdiction either to answer legal questions on international climate obligations, which are the advisory opinions, or deal with climate cases. Until now, only the European Court of Human Rights had decided on a climate case at the international level. So I will take some time to explain the main developments in this case. The talk will end with a set of takeaway messages that highlight the advantages of having climate litigation taking place before international courts and their fundamental role in the multi-level dialogue needed for an adequate response to climate emergency. As I've already said, climate litigation has increased exponentially in the past years. There are thousands of cases around the world, both before national and international courts. There are about 2,600 climate litigation cases in the database of the London School of Economics, and around 70% of these cases have been filed since 2015, which is the year the Paris Agreement was adopted. Climate cases are spreading to more countries around the world, as you can see in this world map. And many of them are dealing with human rights. But today, my intention is to focus on the possibility for climate litigation cases before international tribunals. So it is important to define first, what do we understand when talking about international climate litigation? And that is any action before an international tribunal or organ which deals fundamentally with climate change, either in the framework of the resolution of a contentious case or the response to a request of an advisory opinion. Contentious cases refer to the legal disputes that can arise between states and are brought before international courts or tribunals for resolution. Advisory opinions are the legal advice provided by some international courts, and they are not binding, which means it is not mandatory for states to follow this legal advice, in theory. Regarding the international courts, we need to bear in mind that there is no international tribunal that deals only with environmental matters or with climate change issues. So we need to take a closer look at the existing international tribunals and see if they can have competence to solve disputes regarding climate change. Most of these tribunals have dealt in the past with environmental cases, but climate change is still a matter that is new to most of them. Let's examine the ones that either have pending decisions or have already rendered a judgment. In this sense, I will start with the request of advisory opinions to some international tribunals. First, we have the International Court of Justice, located in The Hague, which is the main judicial organ of the United Nations. It has universal jurisdiction, what means that it can solve any type of dispute that deals with international law, for example, the compliance of the Paris Agreement. But only states can bring cases before the ICJ against other states. So international organizations, individuals, or NGOs cannot bring any case at all. So far, there hasn't been any case regarding climate change before the ICJ, and it's very unlikely that there will be any in the future. But the ICJ has another very important competence, which is to answer legal questions of UN or United Nations organs and institutions. And precisely, there is one advisory opinion pending before the ICJ, submitted by the General Assembly of the United Nations in March 2023. It was a request promoted by the small island developing states, such as Palau, Tuvalu, Vanuatu, that started a campaign in 2019 together with the students from the University of the South Pacific in Vanuatu. This initiative has been supported by many countries and organizations of the international civil society. The International Court of Justice will need to answer the question, and I'll show you the question posed, of what are the climate obligations of states provided by the international climate regime, but also in the light of principles such as no harm, due diligence, good faith, cooperation, prevention, and precaution, and all that in order to protect the rights of present and future generations. It would also bring some light on the legal consequences of the acts and omissions of states regarding these obligations, especially for developing countries that are in the most vulnerable situations, such as the small island states. This advisory opinion is not binding for the states, as already said, but it can bring some clarity and some coherence between human rights obligations and international climate obligations. Then we have the International Tribunal of the Law of the Sea here. That deals basically with disputes regarding the application and interpretation of the 1982 Convention of the Law of the Sea, UNCLOS, that may arise between the states parties. It has dealt in the past with some relevant environmental issues, such as overfishing or maritime contamination by radioactive materials or by oil extractions, but it has not solved any climate dispute yet. As with the ICJ in December 2022, the International Tribunal of the Law of the Sea received a request from the Commission of Small Island States on Climate Change and International Law to render an advisory opinion on the specific climate obligations under the UNCLOS. In other words, if states parties to UNCLOS are obliged to mitigate climate change in order to comply with this convention. On the 21st, and I'll show you also the actual request. On the 21st of May 2024, the court delivered its unanimous advisory opinion finding that greenhouse gases emissions constitute pollution to the marine environment, and therefore states have the obligation of due diligence to take all necessary measures to prevent, reduce, and control marine pollution from anthropogenic greenhouse gases emissions, taking into account the best available science. And the last advisory opinion is the one pending before the Inter-American Court of Human Rights, which is a tribunal based in San Jose, Costa Rica, that has as main task the protection of human rights in the American Convention of Human Rights and its protocols. The Inter-American Court of Human Rights has shown a special interest and openness towards environmental issues, always related with human rights, especially concerning vulnerable populations such as indigenous people. It has protected their ancestral lands, which also means the preservation of their national resources. The court has many times recalled that the environmental degradation and the adverse impacts of climate change affect the enjoyment of human rights. It has not ruled on climate change, but there is this advisory opinion pending and that was requested in January 2023 by Colombia and Chile. They asked the court to clarify states' obligations on the matter of climate change and human rights. This link between human rights and climate change, brings us to the first decision of an international tribunal on a climate case, which is the European Court of Human Rights. This court is an international court of the Council of Europe, which is based in Strasbourg, France, and has nothing to do with the European Union. It is the court in charge of controlling the implementation of the European Convention of Human Rights. So it hears applications when a contracting state, for example, has violated one or more human rights of the convention and its annexes. There is not an explicit recognition of the right to enjoy a healthy environment in the European Convention, but it has not prevented the European Court from ruling on a considerable number of cases with environmental content. In fact, there is a case law, a jurisprudence on environmental matters where the court has considered that severe environmental damage can affect the enjoyment of some human rights in the convention. The most significant examples are when severe environmental damages affects the right to life, Article 2, but especially the right to enjoyment of a person's home and their family and private life, Article 8. In fact, Article 8 of the Convention has been, and still is, the key piece of the effort made by the Court to green the European Convention of Human Rights. The European Court has made an extensive interpretation of this provision, understanding that the respect for the home is not conceived only as a right to a physical space, but also as the right to enjoy that space in tranquility. That means that interferences such as noises, polluting emissions, smells, or other disturbances may very well constitute a violation of Article 8. It was first decided in the case López Ostra versus Spain in 1994, where a waste treatment plant was situated near the home of Mrs. López Ostra, causing a huge distress in her daily life and sleep because of the smell and the noises produced by the plant. Since then, many other cases regarding clubs, mining activities, airports, highways, etc., that had significantly affected the well-being of people have been considered contrary to the convention when states have done nothing against it. And precisely, that is also the rationale behind the climate cases that have reached the European Court of Human Rights. Over 10 cases have been submitted by before the European Court, although the court has only rendered a decision on 3 of them, the ones that you see in your computer. The first case to reach the European Court was Duarte Agostinho, filed in September 2020 by a group of 6 Portuguese children and young people against 33 member states. They argue that all these states were not acting sufficiently against climate change, and therefore they were violating fundamental rights of present and future generations, such as the rights to life, Article 2, and the right to respect their home and enjoy the private and family life, Article 8 again. 2 months after, the court admitted the case Verein Klimaseniorinnen against Switzerland. It was filed by 4 old women of Swiss nationality and an association representing over 2,000 women who considered that climate mitigation policies adopted by Switzerland are insufficient, resulting in a serious attack on their fundamental right to life and health. Again, Article 2 and 8 were at stake. The third case was filed by Mr. Carême, which is the former mayor of Grand-Sainte, a town in the Bretagne in France. And it's a town that is in great risk of flooding because of the rise of the sea level caused by climate change. On the 19th of April 2024, almost a year ago, the court delivered its decision on these 3 cases, but it decided on the merits in just one of the 3, the Klimaseniorinnen case. The cases Duarte Agostinho and Carême were dismissed on procedural grounds. That means that they could not fulfill some admissibility requirements in order to get a decision on their rights, to know if they have been violated or not. In Duarte Agostinho, the court considered that the Portuguese kids could only bring a complaint against their own country, Portugal, and then they should have first conducted litigation in Portugal before coming to the European Court, which is known as the requisite of exhaustion of domestic remedies. In the case of Carême, the court decided that Mr. Carême had no victim status because he was not longer living in France, but in Brussels, because he was elected as a member of the European Parliament. And therefore, he was not directly affected by climate change in his hometown. In the case of Climate Seniorinnen, the court considered that the four elderly women did not have victim status either. And that is because they could not demonstrate a direct and individual effect of climate change in their lives and health, or at least they were not more affected as other people in the court's opinion. But the court considered that the association, the Verein, did have standing. So we have a case where an association or NGO can bring a claim before the European Court of Human Rights, although its members cannot do it individually. It is a bit confusing, but at least we have a judgment of the European Court of Human Rights that clarifies states' obligations regarding climate change and human rights, at least within Europe. There are some lessons to be drawn from this case. The most important one is that states are not doing enough to fight. The most important one is that when states are not doing enough to fight climate change, they are not fulfilling their due diligence obligations, and therefore they are not protecting fundamental rights in the European Convention. In other words, states parties have an obligation to develop and to apply comprehensive policies and regulatory frameworks of reducing greenhouse gas emissions that allows them to meet the ambitious 2050 carbon neutrality target of the Paris Agreement. This judgment will have important impacts on forthcoming cases before the European Court, but also before the domestic courts of states parties to the convention. And then I'm coming to the end of my presentation with these takeaway messages that are also meant for our further discussion. The first one is that climate change is a matter of human rights. It affects people's life, and it can have legal consequences. The second idea is that the international litigation can be a very useful tool to control insufficient actions or inactions of states to fight climate change, although it can also have some risks. International court decisions can clarify existence and content of climate obligations as long as they are not contradictory or vague. Also, judicial activism can have a negative impact on climate negotiations. Maybe states can feel that if they agree to some compromises, they can be controlled afterwards for not complying with them. But despite these risks, it's worth supporting these initiatives since it can bring other advantages, such as, for example, increasing the visibility of the climate change crisis around the world. It can also bring support to climate litigation within states at a national level, because national tribunals can always take a look at international level to the jurisprudence of international bodies and courts for support and inspiration. And it can also bring coherence with other international regulations in the case of the advisory opinions, for example, such as the human rights, law of the sea, migrations and refugees law, because human change affects all of them. So that would be all from my side. I want to thank you for your attention and tell you that I'm open to discussing questions and comments that you may have. Thank you very much.
Thank you so much, Rosa, for an absolutely spectacular and presentation. It was super pedagogic. Really enjoyed it a lot and learned lots.